mode.
Good morning and welcome to our webinar, Real Estate Deeds and Taking Title to Real Estate. I'm Sherry Davidson, President of Davidson Realty. Davidson Realty has been selling real estate in northern St. Johns County for over 20 years. My guest this morning is Jason Hill. Jason is with the law offices of Curtis & Hill. Jason has been practicing real estate law since 2001 and has recently partnered with Bill Curtis to assist clients with all of their residential and commercial real estate needs throughout Northeast Florida. There's a box on your screen this morning, and please feel free to type in any questions throughout our presentation. We may answer them at a break in the presentation, or we may answer them at the end, but just feel free to type them in at any time. So I will turn it over this morning to Jason.
Thank you, Sherry. This morning we're going to be discussing real estate deeds and taking title to real estate. Now, most people know that a deed is a legal document that transfers ownership of real estate from one person or entity to another person or another entity. However, what a lot of people don't realize is the warranties that go along with the transfer of property via a deed. The first way to transfer property is via a warranty deed, also known as a general warranty deed. Now, these deeds not only transfer ownership of real estate from a seller to a buyer, but these legal documents constitute explicit warranties, promises that the seller is making to the buyer regarding the real estate transaction.
Jason, when would you most likely see a warranty deed?
Warranty deeds are typically used when there's a transfer of ownership between individuals from one person to another. However, when a bank or a corporation or a business or a home builder is the person selling the property, you're typically going to see that property transferred via what's called a special warranty deed. The practical difference in the two types of warranty deeds may best be considered as one more of the scope of protection than the kind of warranty. Whereas a general warranty deed is distinguished from the special warranty deed is that it contains a guarantee from the grantor that title to the real property is superior to any person who makes a claim, whether such person claims through the grantor or otherwise. Whereas the special warranty deed provides only that the grantor has not done anything to impair the title to the property during the period of his ownership, and the warranty is limited to those claiming through the grantor. Another way to take title to property is via a quitclaim deed. Now, a quitclaim deed transfers a person or entity's interest in a parcel of real estate but makes no warranties or promises to the buyer or the person who is receiving the real estate. Quitclaim deeds are typically used by divorcing couples who wish to transfer real estate from both spouses to one of the spouses, or when people leave real estate to family members through a trust, a will, or other estate planning documents. A quitclaim deed can also be useful if there is some sort of cloud on the title or some conflicting claims of ownership or unclear title history. By quitclaiming his or her interest in a parcel of real estate, the grantor can effectively clear the title to the property and clarify its ownership.
Jason, could you give me an example of what a cloud on title means?
Sure. A cloud on title occurs when there's a break in the chain of title, and where I see this typically occur is, for example, when a woman takes title to a property individually in her maiden name and subsequently becomes married and sells the property. So in this example, she would take the title to the property as Mary Smith when she was individual. She got married, she became Mary Jones. Now when they sell that to a new person, she sells it as Mary Jones in her married name. Well, there's a break in title because when you look at the public records, it was originally deeded to Mary Smith, but then it was deeded from Mary Jones, and there was no connection between the two. So this would be a good instance where you would use a quitclaim deed, and you would have her use her maiden name, Mary Smith, and quitclaim any interest she may have as Mary Smith to that new third party to which she had also done the deed previously as Mrs. Jones.
Thank you. I have heard that sometimes parents will quitclaim their home to their children so they can avoid probate. Is this the best way to handle this?
Sure, that used to be the best way to do it. However, they've recently created what's called an enhanced life estate deed. It's also known as a labor deed. And this is a document that allows parents to deed their home to their children, but reserve a life estate for themselves, coupled with the ability to sell the property at any time. In layman terms, what this means is that the parents still own the property. The parents can sell the property at any time without notifying their beneficiaries. And if the parent never sells the property, the house will pass directly to their beneficiaries upon death without going through probate. Now, some of the other benefits that are afforded via a ladybird deed is that the transfer of property does not result in capital gains for the beneficiaries because they will not actually receive any value until the grantor passes away. When the grantor passes away, the beneficiaries take the home at a stepped-up basis, not the grantor's original basis. Stepped-up basis is the value of the property on the day of the grantor's death. This is an important consideration that should be discussed with your accountant when you're contemplating using an enhanced life estate deed and how that can be beneficial. Now, another advantage of the ladybird deed is it does not open the property to the beneficiary's creditors during the grantor's lifetime because the beneficiaries have no interest in that property until the grantor has passed away. Also, the grantor may sell the property at any time compared to a regular life estate where a grantor would not legally be entitled to sell the property. So the biggest differences between a quitclaim deed and an enhanced life estate deed are as follows. The problem with a quitclaim deed is that the parents would not be able to sell or encumber, i.e. mortgage their property without the consent of the beneficiaries because the interest is already passed to the beneficiaries. Also, a transfer via quitclaim deed reserving a life estate for the parents allows creditors of the beneficiaries to obtain an enforceable lien against the property because the beneficiaries cannot claim the property as homestead and all the protections that are afforded via homestead while the parents are still alive. Also, spouses of beneficiaries can claim an interest in the property that are transferred via quitclaim deed either upon the husband's death or in the event of the wife or husband's the divorce of the couple.
Jason, let's talk about different forms of ownership now.
Sure, there's several different ways that you can take ownership to a property. The first I'm going to discuss is sole ownership. The first example is where a man or a woman, where they're individual, they're not married or legally divorced. An example of that would appear on the deed as John Doe, a single man, where a married man or woman wishes to take title to a property individually. That would occur as follows. John Doe, a married man, has his sole and separate property. Now, where a married man or woman wishes to acquire title as their sole and separate property, the spouse must consent and relinquish all right, title, and interest to the property by deed or other written agreement. However, this does not apply to homestead property as the spouse cannot waive that interest. The final way that somebody can take ownership of a property solely is through a living trust. And a living trust is created while an individual is alive and gives the individual control of the distribution of his or her estate. The individual transfers ownership of his or her property and assets into the trust. Another way to take title of the property is jointly. And the first way that I'm going to discuss is community property and joint tenancy. Now, community property only applies to community property states of which Florida is not. So I'm going to skip ahead to joint tenancy and discuss the benefits and the ramifications of taking title as joint tenants. Joint tenancies, what that does is that creates a joint and equal interest in the land owned by two or more individuals created under a single instrument with right of survivorship. What this means is when an individual owner dies, his or her share in the property is automatically distributed equally among the remaining owners. For example, where there are 3 owners on title, each owner automatically owns a 1/3 equal interest in the property. Now, if one of those 3 owners were to die, then the remaining 2 owners now automatically own equal 1/2 interest in the property. The way that this would appear on a deed the grantee would show up as John Doe and Mary Doe, comma, husband and wife as joint tenants. Now, any number of individuals can take title as joint tenants. Their interests cannot be divided, and there is only one title to the whole property, and possession is equal amongst all of the joint